Welcome you here tonight to a wonderful seminar by Professor Elise Bant on Systems Intentionality and a new model for corporate responsibility. I'd like to start by acknowledging the traditional owners on the lands on which we're meeting, both physically and virtually, and pay my respects to their elders, past, present, and emerging. Many of you will know Elise very well as a former member of this faculty, but for those of you who don't, Dr. Elise Bant is a Professor of Private Law and Commercial Regulation at the University of Western Australia, a Professorial Fellow at the University of Melbourne and a Fellow of the Australian Academy of Law. Elise also acts as a Specialist Consultant to HFW Australia. She's a General Editor of the Journal of Equity with Professors Simone Degerling of the UNSW and Ying Kai Liu of this faculty. Elise's main areas of teaching and research interests lie in the fields of unjust enrichment and restitution law, contract and consumer law, commercial regulation, civil remedies, property, equity and trusts. And together with Professor Jeannie Marie Patterson, also of this faculty, Elise has held a series of ARC grants into corporate and commercial misconduct, culminating in her appointment as an ARC Future Fellow. But tonight, Elise is going to be talking about different ways to attribute responsibility to corporations. And without more, I'll hand over to Elise.
Thank you very much. So thank you all for joining me here, and also thank you to those joining online. As you'll know, minds matter in the law, so it really does matter for a whole range of purposes, both for civil law and also for criminal law, for private law, across a whole spectrum of the law. Minds matter. It matters whether an act is done intentionally, with knowledge, by accident, through mistake, and associated normative assessments of conduct. For example, whether an act was done dishonestly, recklessly, unconscionably. All of these assessments depend on proof of some mental state. And so for regulators, of course, this is at the heart of what they do. If a regulator is thinking about how to frame a claim, what kind of misconduct has occurred, whether it's even appropriate to start thinking about, for example, settlement or some form of enforceable undertaking, or in jurisdictions where they're possible, some sort of deferred prosecution agreement. Those sorts of questions can't be addressed without thinking about the mental state with which the conduct occurred. Even for strict liability claims, such as for misleading conduct, mental states lie at the heart of penalties jurisprudence. So it matters whether misleading conduct was knowing, deliberate, mistaken, whether there's contrition shown for the misleading conduct. All of these things matter for natural persons who engage in misconduct, but also for corporations. Next slide, please. Now, for corporations, of course, we're stuck with the fact that we're dealing with artificial persons, not with natural persons. They don't have a natural mind. And so it's not surprising that traditionally our attribution principles have looked for some human repository of fault for, whose mind can count for that of the corporation. And I call that kind of approach a Where's Wally inquiry, because we are looking for a natural repository of fault in amongst the very many people who may be involved in corporate activities. So the traditional approach, of course, is to look very much to the members of the board, to the directing mind and will. More recent developments in the law, for example, the approach in Meridian, which I think personally is a sort of approach in statutory interpretation, looks at the person whose mind counts for that of the corporation for the purposes of this prohibition or requirement of the law. So it's an exercise in thinking about who is identified as the relevant person for this particular legal enactment. more expansive statutory rules, such as under the Trade Practices Act, cast the net more widely still and simply ask what was the relevant mindset of the person who engaged in the relevant conduct, and deems that mindset to be that of the corporation. But in all of these cases, we're looking for a human, we're looking for a natural person. And this is problematic. Next slide, please. Vicarious liability, I'm going to put off to one side at the moment because it's probably understood it's a form of derivative liability whereby a corporation is held responsible for the wrongdoing of another person, whereas I'm interested in circumstances where the corporation is in trouble on its own account for, and we're looking for its mind. Now, problem in the modern corporate context is if we're looking for individuals on whom we can hang corporate fault, that becomes increasingly difficult as you're dealing with complex corporations with diffused lines of responsibility. So we see very commonly that there are information barriers, for example, that will exist within a corporation that's, prevent knowledge from rising to the responsible officer, for example. There will be a huge changeover in humans so that, it's not possible to identify which person in the chain held the requisite scintilla of knowledge at the relevant time. There's the fact that humans change the way they behave when they operate in corporations. They engage in groupthink and adopt different values and personas. Quite apart from, next slide, please, the problem when we deal with automation and algorithmic contexts where the search for a repository of responsibility really becomes fanciful. We don't have artificial intelligence of the kind that we saw in that delightful film, Where's Wally? There's not a little creature out there that's thinking and directing the traffic in the same way as do human agents. So if we're looking for some sort of algorithmic agent to lay the blame through to the corporation, we are in trouble. So what can we do about it? Next slide, please. Corporate culture provisions have been an absolutely, I think, outstanding contribution to the law made by law reform efforts over a long period of time, culminating in, I think it was about 20 years in the making, culminating in these provisions. Those provide that corporate intention, knowledge or recklessness can be demonstrated where a corporate culture directed, encouraged, tolerated or led to misconduct. And corporate culture is defined as an attitude, policy, rule, course of conduct or practice. Now, the striking thing about these provisions is that they represent an organisational theory of responsibility, looking at corporations as a whole, taking a holistic approach, thinking about how corporations operate on their own terms rather than just through the lens of natural individuals who may work for the corporation. These have been enormously influential in Australia. If we just pause for a moment to think of recent royal commissions, corporate culture really sat front and centre of those inquiries. They're embedded in our ASX guidelines. They directly and explicitly inform civil penalties jurisprudence, the corporate culture that's in place when a corporation, for example, engages in misleading conduct, which itself effectively operates as a strict liability prohibition, is directly relevant to the setting of penalties. So wonderfully, valuable as a regulatory tool and as a governance tool also, but hasn't been successful at all as the liability mechanism. In fact, we've never had a single case proceed to decision on the corporate culture provisions, and they've been excluded from most places where they would be most relevant. Why? Well, because we've never really worked out, well, in my view, firstly, we're not really sure what corporate culture is. And secondly, we're not sure how, whatever that is, it relates to the doctrinal elements we require for responsibility purposes in our law. Things like knowledge. What is the relationship between corporate culture as a general idea or as it manifests in a particular corporation and knowledge of some particular fact or matter? What about intention? You know, general and specific intention. You know, how does corporate culture bear on recklessness? So, you know, there's a bit missing in the puzzle. Next slide, please. And that's where I come in. So my model of systems intentionality seeks to develop a more practically workable conception of corporate culture. So it builds on corporate culture. It also builds on a whole range of fabulous jurisprudence, which, you know, is of quite some age and complexity. Also, recent prohibitions that were introduced in our major competition and consumer acts and in our financial services legislation around unconscionable systems of conduct. Those sort of sources have given rise to my model, which is really quite straightforward. It simply posits that corporations manifest in the sense of reveal and instantiate or give effect to their states of mind through their systems of conduct, their policies and practices. Now, what is a system of conduct? Well, these aren't terms of art. They're things that we identify in our everyday life. They're coordinated steps. They're elements of a plan. They're procedures. They're processes. They're schemes, strategies. All those sorts of words all denote systems of conduct. They're ways in which you have a plan of procedure or an internal method which combines steps in a coordinated way to some end. And framing it in that way, as we'll see in a moment, you can see that systems of conduct, as I understand them, are inherently purposive. We have systems of conduct to do something. Practices are just systems of conduct that have a tendency to develop organically from the ground. So I wanted to make sure I captured those sorts of systems of conduct that develop through repetition. They're patterns of behaviour that become customs or habitual responses to certain positions or scenarios. A policy is an overarching, if you like, system of conduct that operates at a high level of generality and which really represents the overall, if you like, values or beliefs or understandings, intentions of a corporation that prompt the more granular systems on the ground. So you might have, for example, a policy around employee welfare and safety, which nudges and directs and guides the more granular practices that develop in a workplace on the ground. Okay, so to recap, systems intentionality states that a corporation's system of conduct reveals and instantiates its intention. So another way of thinking about this is that corporations lack natural minds and so must think through systems of conduct. Boards of directors are the most baseline system of conduct that we generally have for corporations, but of course there are many more. Ones that we're very familiar with are standard operating procedures, for example, but there can be more devolved and diffused systems of conduct. Importantly, I conceive systems of conduct as applying over time. Normally systems are repeated, so they apply over time. For that reason, when I'm thinking about a system of conduct, not only do I think about the proactive elements of the system, but also what's been omitted. And that includes, you know, omitted perhaps audit or remedial functions, or hopefully they're included. But because a system plays out over time, there should actually be some sort of feedback loop within a system so that the system can evolve and change over time in response to its circumstances. Systems are inherently purposive. They coordinate and connect steps to some end. Importantly, and so if you like, if we put it in doctrinal terms, a system of conduct always manifests a corporation's general intention to act in a certain way That's the whole point of having the system. It coordinates conduct in a certain way. So that expresses the corporate general intention. Sometimes systems will be arranged in such a way as to produce certain outcomes where there's only one outcome. That's the specifically intended result of the system. Where there are a range of outcomes, it may be possible to work out that there are, you know, a range of potential specific intentions manifested through this system. How a corporation reacts to the system it deploys will also be revealing as to its intentions. Finally, there's also certain knowledge which is manifested in a system. In essence, systems rarely work by accident. Systems are coordinated steps geared towards some end. They will have a certain design, objective elements or arrangement. In order for a corporation to deploy a system according to its terms so that it works as designed, a corporation must have knowledge of those you know, required steps to make it function. Just as if I'm applying a cake recipe, which is a system of conduct, I have to know what flour is and beating eggs and so on to get the cake to be produced according to the terms of the system of conduct. So too it is with corporations. The trick is, of course, that whereas with me, because I'm human, I have a memory and I have intuition, so I may jag the cake correctly. With corporations, they lack natural mental states, so they have to have systems in place, and we can treat them as understanding what's required for those systems to operate according to their terms. Now, how do we identify the systems? Well, they're not the glossy things we see on the websites, the ones that say we have a responsible gambling policy that's of world-class quality, which is contrary to the true practices of the casino operator. Rather, we have to look at the systems of conduct that are instantiated on the ground. It's very important that we go to the real life systems because that's where we find the true corporate mental states. And that's also a really good way of working out whether a corporation is engaging in greenwashing or other forms of deceptive conduct by saying that its values and purposes and so on, for example, are, you know, responsible and ethical all the time, while its own actual intended practices are quite different. So we find evidence of systems of conduct in a whole range of different ways. And there is a huge body of law on this from the unconscionable systems of conduct jurisprudence. I won't go into that now. I've written on it extensively in that book, The Culpable Corporate Mind. But none of this has to be made up. It's already there, being done, being litigated, and we have templates for how to prove systems of conduct and how to understand these as bearing on particular mental states. Next. But I'll give you a few examples, and this will give you a flavour of how it works. So you will all no doubt recall the fees for no services scandals, which became public and really of particular public concern during the Financial Services Royal Commission. Commissioner Hayne was faced with a whole series of senior executives of different banking institutions who had been charging fees for life insurance and taking fees from customers who had died. And that had been going on repeatedly and for long periods of time. Now, again and again, those CEOs said, we did not know. And by saying that, of course, thereby attempting to whitewash the corporate conscience, because if the directors didn't know and the responsible officers didn't know, then the corporation doesn't know, says the traditional attribution rules. Likewise, they pointed to their employees who were notionally in charge of this, you know, automated system and said, oh, look, and we've got hardworking, honest employees. So therefore, our corporation must be hardworking and honest as well because our employees are. But another view is possible. Organisationally, these are automated systems that reflect deliberate corporate choices in their design. What does the corporation know? It knows that it is taking, through an automated process, fees from humans. Why do we know it's humans? Because it's life insurance, natural customers, and that those takings must be authorised. Secondly, what does the corporation know? That those customers' circumstances are likely to change. Most likely, they're likely to die. That's why they're getting life insurance. Thirdly, corporation knows that unless it has in place appropriate mechanisms, those takings will become necessarily unlawful when the customer dies. Now, in those circumstances, a choice not to have any monitoring or adjustment mechanism speaks loudly as to the corporate's values and intention. What does it say? Well, it says something along the lines of, well, we know that inevitably we will engage in unlawful taking if we set off this automated system in this manner, but we're going to do it anyway. Now, that counts for my purposes as reckless behaviour, because it's conduct which is engaged in knowing of the inevitable consequence. Considering that these were all specialist expertise-ridden organisations, these were corporations of considerable experience. Judged against the standard of that kind of organisation, I'd have to say I would personally count that behaviour as dishonest, contrary to the standards of an honest financial institution. It may be that there was not a specific intention to use language of some commentators, steal from a particular customer, but banks well knew that this was the inevitable consequence of their system. So there are some profound things that come out of this simple set of ideas. And if we go to the next slide, these ideas were picked up in the Crown Casino Royal Commission by Commissioner Finkelstein. Crown Casino was found to have engaged in some pretty poor practices over a very long period of time. This was one that I focused on in submissions to the Commission. Millions of dollars were laundered through two Crown accounts, the South Bank and Riverbank accounts. What happened was that not everyone is aware that there are anti-money laundering requirements, so that when suspicious deposits are received into accounts, usually deposits just under $10,000, they should be reported as suspicious activities or suspicious transactions to the relevant regulator or authority. What had happened, though, was that Crown cage staff who were in charge of these accounts had developed a practice of amalgamating or aggregating payments into those Riverbank and South Bank accounts. So instead of the anti-money laundering team being able to see that there had been 5 deposits in one day just under $10,000 that were suspicious, instead the anti-money laundering team was receiving from the cage staff, the frontline cage staff, just a lump sum report. So that necessarily the anti-money laundering team had no capacity to identify suspicious activity. And unsurprisingly in that context, Crown said proudly that it had never had any instances of money laundering activity on its accounts ever. Now that should have, set off a red flag somewhere, but the important thing was that Crown went through the same thing that we saw with the Royal Commission. The members of the board said, we did not know. We had no idea, our managers did not tell us. We were in no way identified of this problem, even though the banks had repeatedly been saying this is extremely problematic. And they had, in fact, had accounts closed because banks refused to deal with them, given this practice. Secondly, they said, our cage staff are hardworking and honest. And of course, individually, they are. It's the organisation and its systems which is the problem. And through the lens of systems intentionality, what you see again, sort of things, that start to look a bit familiar. You see that organisationally, there must be knowledge that the cage staff activities of reporting suspicious, deposits and the anti-money laundering team cannot be kept structurally separate, that the one depends on the other. There has to be some sort of check that what the cage staff is doing is giving the anti-money laundering team what they need, and that was never done. Structurally, they were kept strictly separate. There were no audits that were done between the two. There was no checking, there was no oversight, there was no communication. And so, unsurprisingly, it turned out that Crown facilitated money laundering over a long period of time. Now, they said this was an accident. We were looking but could not see. Now, the Bergen inquiry accepted that because they, Commissioner Bergen was looking at the individuals involved and said, well, individually they all seem honest, if somewhat inept, But through the lens of systems intentionality, again, another assessment is possible. That is that these were Crown's own systems, that it had corporate knowledge of the necessity for these areas within its corporation to be intimately connected, to be regularly audited, not for Crown to be engaging in facilitating criminal activity. And it chose not to do that. Now that looks reckless again. I have explanations for recklessness in my more expansive writings, but it looks recklessness and again, dishonest. I'm continuing the same vein. Just thinking about the Crown Casino again, it's a gift that keeps giving. Star Casino is much the same. Endless source of delightful case studies on corporate misconduct. There you had marketing strategies that were put in place over some 20 years that were designed to bring elderly members of the community to the casino to engage in a day of entertainment. The problem was that the various elements and characteristics, the features of these systems, to my mind, manifested a predatory mindset. You were dealing with older Australians, many of whom were had English as a second language. They were financially illiterate in many cases, and certainly not financially astute. They were bussed out to the casino with a range of incentives, including the free bus travel. That they were often approached through community groups that were given incentives to engage in this activity through various different financial and in-kind benefits. In order for the community groups to receive the Crown subsidies, the participants had to stay at the casino to 4 to 6 hours. Now, a lot of these people were quite elderly. And so you have to think about, well, what is the absolutely cast iron guaranteed outcome of having older people in a casino for a long period of time who fall within this demographic, not just including the age, but also the lack of financial sophistication, English, the second language issues and so on. And sure enough, they gambled extensively. There were a whole bunch of reported harms that came out of it. Interestingly, those audits and investigations were not carried out by Crown. They were carried out by independent agencies that were concerned about the welfare implications. Many of these participants reported, for example, not being able to afford to pay for medication and being determined to come back next week when they might be luckier. All the time, Crown had a beautiful responsible gambling policy on its website, which was quite at odds, said Commissioner Finkelstein, with the reality of the circumstances. Now, when a corporation represents that it's adopting a responsible position, that it cares about its customers and so on, it is making a representation of fact. The state of a man's mind, says Edgington and Fitzmaurice, is as much a fact as the state of his digestion. And, added the UK Supreme Court in relation to a corporate case, the same is true of corporations. So these are representations of mental states. And on my analysis, Crown Casino well understood that they were wholly false. This is deceptive conduct, not just misleading. And indeed applying equities, rules around unconscionable conduct, which require the presence of known special disadvantage on the part of the victim and exploitation of that special disadvantage. Crown's behaviour was liable to be adjudged unconscionable and predatory. And again, I have some, further writing on that for people who are interested. So the fourth example I'd like to give is failure to prevent offences. Now, some people have argued that given the problems with identifying corporate mental states, the best thing is to chuck that requirement right out the window, move to strict liability, have a different approach for corporations. Now, that would make sense, except for we just intuitively go all the time to mental states as a measure of culpability. We've seen that already when I was mentioning about penalties jurisprudence in Australia has culpability embedded at the heart of it. So it's hard to get away. These are sticky ideas. But nonetheless, a different model of corporate responsibility has recently been very much in favour and has recently, in fact, been adopted into Australian law. These are failure to prevent offences. The UK models on which the Australian version is based generally have two limbs. Firstly, you have a predicate offence. So in our case, an act of bribery. And secondly, the onus then flips onto the defendant company if the bribery was carried out by an associate of the defendant company. That's normally very widely framed, so it could be any employee or agent or associated company, so quite broadly framed. The onus falls on the defendant company to show that it had reasonable proportions or adequate procedures in place to prevent that bribery. Now, what that second limb is a limb that looks at systems of conduct, policies and practices. That's what courts generally tend to drill down into, to think about whether or not there should be, if you like, mitigating considerations when it comes to the corporation's responsibility. Should they be relieved in full of responsibility of the act of bribery of their associate, or should it play off in some other way through penalty or indeed the deferred prosecution agreement mechanism, which we don't have in Australia, I don't think. Yes. So I just thought here, since I seem to be engaging in an endless series of character assassinations of well-known companies, that we would think about the Rolls-Royce bribery scandal. Now, in that case, Rolls-Royce engaged in corrupt bribery practices that were endemic across multiple jurisdictions and across a very long period of time. When these matters came before Lord Gold, I think it was, Lord Gold. Anyway, I've forgotten which Lord it was. He noted that these bribery practices seemed to be endemic to the corporation, that they were remarkable in that, even when the corrupt individual employee left or was promoted, the corrupt bribery practices continued, and this was shocking, that there were, many instances where senior officers were found directing the traffic, but there were some cases where no senior officer could be identified as directly implicated in the bribery practices. And in those cases, rather than being able to proceed directly against Rolls-Royce for being itself responsible for the corrupt practice of bribery, instead, the prosecutors relied on this failure to prevent offence. But through my lens, it's all the same thing. This was Rolls-Royce business model. This was how it did its business. This was how it developed new clients. I mean, you only have to read some of the instances of bribery to realise how organisationally connected this was. In one instance, for example, the bribe took the form of a gold Rolls-Royce. Can you imagine how many man-powers or person powers were involved in producing a gold? I suppose it was gold-plated. I mean, it wouldn't be able to drive if it was completely gold, just sort of sink into the ground as it left the production line. But these were organisational practices. They were deeply embedded. So it's really mischaracterising the nature of the organisational fault for us to call it a failure to prevent someone else's misconduct. This is Rolls-Royce's own conduct. Now, failure to prevent offences are characterised frequently in English courts as involving a lower level of culpability because they're parasitic on someone else having done something wrong. This is a bit like vicarious liability, saying, oh, this employee or this associate did something wrong and you failed to prevent it, so your fault is failing to stop that bad person. Whereas I think, in this case, this was Rolls-Royce being a bad corporate person, and over a very long period of time. It was still fined $500 million, but it was allowed to continue to operate. It wasn't given the corporate equivalent of a death penalty. For which I think they were very grateful. And as the learned judge mentioned in that case, the only reason why he was prepared to go ahead with a deferred prosecution agreement and effectively allow Rolls-Royce to continue to trade was because for a long period beforehand, Rolls-Royce had tipped out all of its management, tipped out all of its directors, had complete board renewal and so on, but realised that heads on stick were not enough, and that's right. It had to engage in systemic change, had to become a completely different corporation was the language used by the judge. So had to completely root out all of those malpractices, all of those bad habits, all of those daily systems of conduct which had become part of who the corporation were. It had to develop, test, embed, audit and remediate systemic reform plans. And this is precisely what Commissioner Finkelstein said in the Casino Royal Commission here in Victoria, and what was also echoed in Perth, in our own Perth Casino Royal Commission. Of course, leaders still matter, and of course, individual responsibility of natural individuals still matters. But, if we're going to be serious about this, we have to get serious about expressing corporate responsibility in organisational terms that responds to the reality of the complex, long-living, in fact, almost immortal creatures that we allow to operate in our midst and have some means of holding them properly to account. My final observation here is that to do this properly takes time and resources in terms of reforming or rehabilitating delinquent corporations. It takes a long time, so and it takes oversight. So in the Crown Casino cases, you all know that the Crown Casino was allowed to operate provisionally under the external monitoring of an independent expert, and years were given for this, and Crown had already been working for years to try and remediate itself. The same was true with Rolls-Royce. It had already for some 5 years been trying to do a root and branch reform of its organisation. It was put under observation for a further 5 years. So this model really points to what's required for corporate responsibility for governance purposes as well as for liability. And that's where I will leave it.
Well, thank you very much, Elise, for that wonderful presentation. It's so impressive the way that you are able to meld the ideas of responsibility that we've developed with human individuals in mind to this construct that we call the corporation.
Yeah.
I don't like to call it a legal fiction because it's very
No,
real,
it's very real.
but it's
yeah.
a construct nevertheless.
Yeah.
And to present it so elegantly and fluidly so that we're all carried along, and it seems as if we must have known it all the time. Now, Elise has very generously agreed to take questions, and we have a little time. So are there any questions from anyone? Oh, there's one over there.
So the second point is
Can I answer the first point first? Because I'm like a goldfish. My memory will be gone in a second. So I have a colleague, Rebecca Faugno, who's doing some very interesting work on corporate culture and systems intentionality. And she has uncovered a whole bunch of cases, largely in the federal court, but not always, in which courts have made mandatory injunction orders that, from our perspective, has a view of mandating corporate culture. That is, they are orders for reform of systems, policies and practices under oversight, quite often, so subject to external audit and review. And this is being done pursuant to injunctive powers. So actually courts can do this. And even if you didn't have a specific injunctive power that was, in our acts, we often have explicit provisions that allow for compliance programs and for orders for systems to be changed and so on. It's actually in there in the legislation. But actually, these are just all mandatory injunctions, and they could be done pursuant to an inherent jurisdiction if you had courts that were willing to go there. So it's a lot easier if you've got the legislative imprimatur, but these are, certainly because systems, policies and practices are something that are objectively ascertained. You're not trying to change the personal values of the individuals within the corporation, interfere with their personal moral judgments and so on. That would be unethical and odd, but it's fine to interfere with the structural and systemic practices, if you like, provided you can do it in a way which is justiciable, in the same way as we know for ordinary mandatory injunctions is always such an issue. They need to be orders that can be subject to supervision in a sensible way and not crushing to the defendant.
so the second point is quite a contestable question in terms of the green bonds. So the question is whether wrong company can issue a green bond.
Yeah.
Yeah.
So I'm not sure. I'm not sure I'm entirely across your question, but certainly greenwashing is readily actionable through this model, because greenwashing is a form of misleading conduct, and because it applies to the corporation's own practices, it's necessarily deceptive because the corporation knows the conduct in which it's engaged, or at least the corporation has to explain how it's not, how it's sleepwalking its way through complex systems of conduct, and that can be difficult. You can have situations where you have corporate groups, again, systems intentionality sort of, has a potential to drive a truck through some of these sort of narratives of exculpation that we see so commonly in corporate groups. Corporate groups can operate simply as coordinated systems of conduct, depending on the nature of the activity in which they're involved. This doesn't come down to shareholdings or anything like that. It just comes back down to the fact that these are individual legal entities, just like natural persons, and just like natural persons, they can engage in systems of conduct. And when they do so, those systems of conduct will manifest certain mindsets. In context of corporate groups, that may well be the parent's mindset if it's the parent's system of conduct that has been put in place. but you know, there will also be potential for accessorial liability and so on. So with greenwashing, you know, you do have situations where parents, you know, issue, for example, policies and statements and so on concerning the overall conduct of its, you know, subsidiaries and so on. And we've seen in some UK cases those sorts of policies being taken as evidence of it's a very exciting little line of music that's being emitted from something. You know, in those circumstances, you know, it can be possible to see that there is a system of conduct that's been put in place relevant to some harm that has occurred, and that is a system of conduct that has been deployed by a parent in which other companies have been involved. So in the context of unconscionable systems of conduct, there are plenty of cases in which corporations have been held responsible for unconscionable systems of conduct that they conducted through not only their own employees and natural agents, but through, you know, automated systems, and also independent companies, you know, that are just, you know, a cog in the greater wheel. And I can't see why it would be any different with corporate groups.
Elise, if I've heard you correctly, most of this behaviour that you've identified has been systemic.
Yes.
But excuses that I read about companies are usually that this behaviour has been caused by a few bad apples.
Oh yeah,
or one
the bad apple. Yeah.
So does that mean, you know, that the kind of proposals that you have in mind are really not going to work with the couple of bad apples, or is it only with the systemic stuff?
So my model actually has exculpatory as well as inculpatory effect. So if you have a genuinely good ethical company that is operating with prudent systems in place that manifest a sensible and careful mindset, and you do actually have a rogue employee out and about there, you know, the bad apple, you can actually have, you know, a system being undermined by that bad apple, and that counts under my model as a genuine corporate mistake, or you know, the corporation itself has been, you know, the victim of the rogue actor. So that is if there is a genuine rogue actor, then that's fine. It's exculpatory for the corporation. However, in most cases, systems of conduct are deployed over time, and the response of corporations to that system of conduct is not to change it and try and track down the rogue actor. In fact, in most cases, the rogue actor is busy getting promoted or given bonuses or whatever. Brent Fissy has a wonderful and very important idea of reactive corporate fault, which is that we can tell a lot from how corporations respond to misconduct that occurs on their patch. And if corporations respond by doing nothing, then that is eloquent as to corporate intentions. And that fits nicely with the idea of systems of conduct rolling out over time. They're repeated behaviours normally, and they roll out over time. Corporations that do not audit, that's a choice. Corporations that don't remediate when they do find something wrong, that's a choice. So, you know, this is all part of the overall system design. So I think it you know, in many bad apple cases, it's, you know, the bad apple is just engaged in the corporate misconduct. And actually, it's the corporation's own practice that the employee is carrying out. And in those circumstances, rather than scapegoating the employee or nailing their, you know, hide to the tree, you know, making them the fall guy, why not use them as a insight into the corporate practice in which they were engaged, and take evidence from them as to that system of conduct for the purpose of holding the corporation to account.
But just very quickly, there could be a predictability of a loophole which allows the bad apple to operate in.
True. I mean, you can just get incompetent companies, like you can get incompetent people, natural persons. But in my observation is that in many cases, when corporations claim systems error, which is one that really got me hot and cross with the Financial Services Royal Commission, this sort of argument that there was an administrative error or a systems error, the machine had just, taken money out of people's accounts and no humans, realised, and so on. Actually, in those circumstances, the loophole is found out because the plea of incompetence doesn't stand against a corporation's own breadth of experience. Casinos that don't understand the realities of money laundering, really. So I think one has to take a sensible approach to assessing these sorts of exculpatory narratives. It's not impossible for a corporation to be mistaken in a circumstance where a system of conduct has played out in a way that wasn't intended, but the onus lies on the corporation to show how and why that occurred.
I saw there was a few other questions in the room, but there's also one online.
Yeah.
Saying, I can understand how systems reflect the actual values of the company. My question is, how do you go about analysing this? Do you look for wire diagrams of the systems, data dumps?
Yeah. I wish my colleague Jenny Patterson was here, because she's the, director of the Centre of Artificial Intelligence and Digital Ethics, and she is absolutely across this. But there was a nice example with Google, right? Google had been engaging in location tracking in a way which was not clear to its customers. And the thing was that in that case, you could look at it from a web design perspective, from the experience of the user. So the user would go on and would like to protect their privacy. They would go to the sort of, the location tracking setting, and that was conveniently set to, off. So they go, oh, great, my privacy is being protected. But unbeknownst to them, there was another place where there was a location tracking setting, which also had to be on off, and that was tellingly switched to on, and it was very difficult to find. Okay. Now, in those circumstances, the default settings of the user's experience was itself allowed as to Google's intention to, harvest information about its customers, notwithstanding its protestations of caring about privacy, because you don't set a default setting to harvest data by mistake. That's just it just seems to me an implausible idea. And another example is again using the own experiences of a customer. Amazon's sign off, the sort of, when you sign up to one of Amazon's services, you can do that in one click, but to unsubscribe famously took 17 clicks, and the screens were like this, and you'd sort of go to click on the unsubscribe and it would move, or and so again, the system of conduct there is manifest for everyone to see, and it really doesn't lie in the mouth of the corporation to say, oh, but we really do care about protecting consumer choice. Well, no, you don't. So I accept that those are simple cases, and it may be much more complex in other settings. I have written on this though with Jeannie, and what I can say is that even with the machine learning algorithms, they have to have guidelines. They're doing something you know, and if they're, for example, you know, their guidelines are to sell as many widgets as possible to as many people as possible wherever they are in the world, and that's the guideline, then what you're deploying is an unsupervised, you know, irresponsible machine learning algorithm that will inevitably degenerate into unethical practices, because it doesn't know any different, because it doesn't know anything. It's just an algorithm. So it's a really good question, but probably that's as far as I can take it at this point.
You've probably got time for one more.
Thanks. I've heard you speak before. I think you've done such an elegant job, as the other commenter said, of just putting something together that makes us feel like we knew it all along. It's marvelous. But I've got a question, a kind of cross-examination.
Yeah,
which is,
lovely.
you seem to be implying that the radical notion that companies actually have a duty to obey the law.
Oh yeah, that's really radical.
And if you would dare put that in a company law context, as Elizabeth well knows, because I think I've done it at some point when you were present, and said that directors or the corporate governance systems of companies under company law have some sort of duty to set themselves up to obey anything other than company law and perhaps profit or shareholder primacy, then at least 50% of the people, probably 80% of them, will argue vociferously with you that there is no such duty.
So it's a really good question, and my model is actually really normatively inert. So my model is actually just about how do we work out what corporate states of mind are. You know, how do we know what corporations intend, what they know, you know, and then using those sort of basic building blocks, how can we then assess them against normative standards like dishonesty and so on. So it's really a fact-finding tool. And it doesn't say anything about what the law should be. It kind of leaves the law to do its own thing about setting normative standards, expectations in terms of obligations and so on and so forth. But where the law does make decisions about, for example, prohibitions on misleading conduct or unconscionable conduct or ESG sort of, reporting requirements or whatever it is that the law says, then what my model does is it enables us to understand the corporate mindset relevant to those legal requirements. Now, to the extent that the law has conceptions of what it means to be an ethical corporation, then my model will assist. To the extent that the law decides to abandon any ethical requirements for corporations, my model will simply be an interesting way of thinking about how corporations think. So in a sense, the model does that the model does the jury work. It says, what was the corporation's intention here? What did it know? What was the plan? Was this harm specifically intended? Was it being reckless? It's making those kinds of assessments. To the extent that they inform the law's prohibitions or the requirements of the law, so that corporate mental states are relevant for regulatory or governance or liability purposes, then it plays that role. Does that make sense? Yeah.
I feel like we could keep going all night, but it's my duty to draw the occasion to a close. For those who are here in person, you might have a chance to ask your questions to Elise over some drinks, but to those who are leaving us online, good night and thank you very much.